This episode of The Benefit Whisper is brought to you by Route 3 Insurance and Financial Services, where smarter benefits begin. If you're tired of rising healthcare costs and opaque insurance contracts, Route 3 is here to help you take control. They specialize in transparent, employer-driven benefit strategies that protect your people and your bottom line. Ready to break away from the status quo? Visit www.fixmybenefitsnow.com and discover how Route 3 can help you build a plan that actually works for your team and for your budget. Welcome back to another episode of the Benefit Whisper, Strategic Insights for Leaders. I'm your host, Ralph Weber, and today we're diving into some of the most important legal and compliance trends that are shaping employer-sponsored plans in 2026. I'm really excited to welcome back a guest, a person I've gotten to know really well, who is one of the favorites among our listeners, Julie Slesnik. Julie has a rare combination of clarity, legal precision, and practical insight into the world of ERISA, fiduciary responsibility, and benefit governance. Her last appearance, we had incredible feedback, and I knew that it was time to have her back. So today we're going to unpack three major developments that every employer, every CFO, every HR leader and broker needs to understand right now. The first one is the new wave of voluntary benefit lawsuits. And Julie's going to talk to us about that. The sleeper Mayo Clinic case. And of course, the rising issue of carrier tactics around withholding year data and or monetizing that. So that's a problem that's becoming more common and more consequential. So these topics are timely, and I am so happy to welcome our guest, Julie. Welcome to the show.
Thank you, Ralph. I'm happy to be back, and I hope I can live up to that introduction. That was very kind of you. But fun to be back.
Well, thank you. I mean, you are great. I've seen you at SIA. We've had you on a couple of episodes, and you always bring that real life clarity, which our listeners love. So let's dive right into the first part. Voluntary benefits. They've been something that has been around for a long time. The Aflac, Colonial, Assurity, Guardian. There are a bunch of carriers. And one of my episodes, I've talked a lot about bankruptcy due to medical bills and the employee share getting bigger and bigger and bigger every year. And a lot of people are saying, a lot of regular, ordinary Americans are saying, I need insurance for my insurance because that deductible they can't afford. So, Julie, let's jump in right from there.
So that is a great opening. And, these new lawsuits, the voluntary benefit suits, we'll call them, they were filed by Schlichter Bogard, which is a firm that did a lot of the K litigation.
Mhm.
And they were filed, the eve of Christmas Eve. So didn't get a ton of attention until early in the new year. And they're basically all the same. And so first I'll give a quick description of what they are, and then we can
Okay.
talk about what this means. So there's four cases. One is against LabCorp of America and their broker, Willis Towers Watson. One is against Community Health Systems and their broker, Gallagher. One is against United Airlines and their broker, which is Mercer. And then there's a case against Universal Services of America and their brokers, which is, again, Mercer and Lockton. So in each case, at least one broker is named, in one of the cases two. And it's the broker that placed these voluntary benefits. So this is a pretty novel use of ERISA. We haven't seen ERISA litigation in this area before, and it's different. Usually you see in an ERISA case, there's allegations of either in healthcare or healthcare related cases, welfare claim cases, you see either improper denial of benefits or improper claims handling. And that's not what's going on here. Here, it's really about fiduciary breaches, and they focus on the failure of employers to make prudent selections of voluntary benefit products and to monitor broker fees. And the brokers, some of the allegations I think are stronger than others. They also accuse the brokers of fiduciary breaches for placing these products, and both parties for engaging in prohibited transactions. And we'll talk about that. It probably is a prohibited transaction. And so the first most important part is that for these cases to succeed, it means that these voluntary benefit plans have to be subject to ERISA.
Okay.
So that's the big question, because up until now, this has been an area where you're right. People have felt they need insurance for their insurance because deductibles are getting higher, coverage gets more expensive. It's expensive to get hospitalized, cancer care. There's a big gap where there's a sort of your own payment amount. And this has been an area where employers have been counseled by their brokers for years that, you don't have to worry about this. We'll just offer that benefit as long as you don't pay anything towards it. So this is exactly what employers, sort of want to hear at this point. They're already paying a
Mhm.
lot for the health plan, for the
Right.
prescription drug program, and they're under the impression that as long as they stay out of it and just let the broker sort of market an insurance product, they can just
Mhm.
collect the premium, pass it on, and that's it. It's not subject to a risk and they don't have to do anything. So these cases challenge that.
Mhm.
And what they say is that all of the employers that are sued here have breached their fiduciary duties to their employees and plan members because they failed to engage in a prudent process when selecting the insurance offerings. And so
Wow.
this is, that's ERISA's basic fiduciary duty of prudence. And then the second one, duty
Sure.
of loyalty, failed to monitor the commissions received by the
Mhm.
benefit brokers and to see if there was any conflict in what was being offered, and failed to monitor the loss ratios in these policies.
Wow. Wow.
So
Even though they're fully insured?
well, yeah, they're fully insured, but the
Mhm.
question is, do they provide any benefit to employees? Why? So one of the questions that's going to come out of this is,
Mhm.
why is the loss ratio so low on these? And most of us, at least me, my only experience with loss ratio until these cases came out was in health plans. And I'm like
Yeah.
85% because I know what the Affordable Care Act says. And
Right.
so that's
Right.
so I get that that's not right and that's not what it necessarily is here.
Mhm.
But I did, since I did a webinar on this a couple weeks back, and since then I've been talking to a lot of people in the voluntary benefits world because they want
Mhm.
to sort of explain from their perspective or tell me things I didn't know. And
Sure.
I really wanted to talk to all these people.
Right. Right.
And their position, what they're saying is, it's difficult to get above 50% of a loss ratio in these policies because,
Mhm.
first of all, I mean, you're issuing, a lot of policies for cancer care, say. Not everyone's gonna get cancer, not everyone's gonna have a claim, and then
Right.
another problem is that because it's sort of a neglected benefit that the employer's
Mhm.
not watching out over and no one's watching out over, employees don't make claims when something comes up. They forget
Mhm.
they have it or they don't file a claim. So, a lot of times,
Right.
employees purchase this insurance and never make a claim when the situation arises. So, those are sort of the 2 main reasons that I was told that the loss ratio is low to begin with. But when we were doing the webinar, I was asking the lawsuits allege that the loss ratio is definitely under 50%, but he wasn't sure what it was.
Right.
But, they show that the broker commissions in each of these cases, they're sort of, and I've learned all kinds of new things from these cases.
Mhm.
Apparently, in voluntary benefits, sometimes broker commissions go in this high low pattern for 5 years. So the first year is a really high commission. Well, that's
Right.
the year everybody's joining. So that's a
Mhm.
good windfall year. And then it
Yeah.
comes down to almost nothing in year 5.
Right. Right.
So he selected pretty good cases because I think like that well, we'll get to it, but the top was like 65, percent
Mhm.
commission year 1. So that's pretty high.
Wow.
All of
Yeah.
them average out to be somewhere around, like, I think the highest one's around 40%. So that's 40 cents of every dollar is going to the broker in those. For mind what's going to the insurance company and anyone else. So you already know
Yeah.
the loss ratio is going to be pretty low. So while I was talking about this on a different webinar, someone wrote in and said that the typical loss ratio that they see in the
Mhm.
group health plan market for these is 18 to 23%. And so I feel like this is one of those situations where
Wow.
judges are gonna be even more unfamiliar with this, and they're not
Right.
going to know either what it should be, but it's gonna
Right.
be sorta like that porn standard at first where, like, I know it when I see it, so they'll be
Mhm.
like, "Well, maybe I
Yeah.
don't know what it's supposed to be, but I know it's not supposed to be that," right?
Yeah.
That seems really
Yeah.
low. So that's sort of the backdrop of these. I've seen a lot of brokers say, "Hey, this isn't fair. We have to make a living,"
Mhm.
and I don't think all brokers are doing something wrong, nor do I think these are all junk plans, nor do
Mhm.
I think that we shouldn't have voluntary benefits. I think that employees, every survey that is taken shows that employees really like them and
Mhm.
want them, and they're useful. And sometimes they fill gaps that are now there, as you pointed out, their
Mhm.
insurance for your insurance.
Right.
So, especially the 4 that are focused on these lawsuits. So, I
Mhm.
don't think the answer is like the knee jerk, let's get rid of them, nor do I think we
Mhm.
should vilify everyone who sells them. I just think
Mhm.
we need to figure out how we're handling these because these lawsuits suggest we're not handling them correctly.
Right. That makes
So,
sense. And because they are an accepted benefit, of course, they're not subject to the medical loss ratio. So
well, they wouldn't be that's right. They're not going to be subject to that. But then
Mhm.
that's right. But they will if they're subject to ERISA, they'll be subject to some sort of prudence standard.
Right,
And
right.
so what
Yes.
will it
Yeah,
be?
and 18 to 33% is definitely not in
Yeah.
that. Wow. Yeah, that's crazy. And I've seen a lot of voluntary benefits, the good, the bad, and the ugly, and some of them are worded like, if you break your leg because you're hit by a southbound train 2 days after full moon, and, like, the is just,
Yeah.
yeah, so much fine print that you could never hit it. And on the surface, the way they're marketed, it sounds good. If you break your leg, you get this, but you have
Yeah.
to be hit by a southbound train, the fine print comes in. So, and of course, the brokers, I agree. They are well-liked benefits. You've got a lot of different types. And the problem is that, as we know, deductibles, out of pocket, employee shares is becoming higher and higher and higher. Okay. And employees just can't even afford to pay their out of pocket. So this is seen as a solution. So the broker is, selling a plan that the employer can afford with a high deductible, but it's not necessarily suitable for the employees. So then they sell something else to make up for the fact that the initial product, is not working the way it should. And
That's
that's
right.
that's my view.
I think that's exactly right. The problem, though, is that, and so something else that I think is really interesting is
Mhm,
two of the defendants, Gallagher and Mercer. I looked at the voluntary benefits section of their websites, and
mhm,
they have a lot of information and information I agree with on there about
mhm,
how voluntary benefits work. And on the websites, it's pretty clear that the governing institutional philosophy is that these benefits should be integrated into the health plan as a whole and governed by ERISA and considered part of the whole.
yeah,
So there's a breakdown between what the institutional message is that's being put on websites versus boots on the ground
mhm,
and what happens, what brokers believe to be true, what they're telling employers are true. And there's just a total disconnect about how to treat these benefits. And I think this is sort of one of those bad areas because no one really thought this was going to be a thing. I don't think anyone's
mhm,
put a lot of thought into this until recently. And
mhm,
and so it has really been ignored. If you think something's ERISA exempt, you're not vetting it. I know that I've worked in places anecdotally. I can tell you that, they're
mhm,
just offered to you and the employer has no idea what goes on with them. And, there's allegations in these complaints that make it worse because they say things like maybe the broker lowered their commission in the health plan and moved it in here. I don't know if they can
rebating.
prove that, but if
Mhm,
that's true, now you've
yeah,
got self-dealing from the employer too.
right,
And
right,
so not only is that prohibited by ERISA, but it's going to make
mhm,
it subject to ERISA. So I think there's a lot of problems here. And I think that employers are going to be surprised because we did a poll when I did this
mhm,
webinar and we asked how many of the employers on the line thought that they offered voluntary benefits that were ERISA exempt, that they were confident about that.
mhm,
And 50% of them were confident. And so some of them were wrong because in
right,
the latest survey done, 80% of these plans are subject to ERISA
mhm,
if they're private commercial plans. And that's
right,
because it's really hard to be in that safe harbor to make you
mhm,
exempt. If you want to be in that safe harbor, there's a strict set of rules. I don't. So first of all, in each of these complaints, the law firm, I would assume, found the information on the 5500s, and that's their big allegation. You put it on a
mhm,
5500. What goes on a 5500? ERISA
mm,
benefits. And
right,
so
right.
it's like an
So that,
admission
yeah,
almost.
yeah,
Do I think
yeah,
that's the winning argument? Not
mhm,
necessarily. And I can see other reasons and defenses, reasons an employer can explain, but it gets
mhm,
you past a motion to dismiss. It's a good
mhm,
allegation and it
right,
suggests that the employer at some level thought it was subject to it. And,
mhm,
that's sort of, so there's sort of four rules, four areas you got to be careful of. And one is that the employer, there can be no contributions from the employer or the union. And that
mhm,
means you can't take pre-tax deductions for any of them.
mhm,
That
right,
that would be
yeah,
considered a contribution. Employee participation has to be completely voluntary. And I don't think that's always clear in open enrollment. It seems like you're supposed
right,
to choose this, and sometimes it's offered as a bundle. And
right,
so I
yeah,
don't know that that's always clear. That is the third area, though, that really gets everyone. And it's that sort of the employer has to be limited to a complete, like, non endorsing role. All they're supposed to do is remove the payroll amounts and pass it
mhm,
on and do
right,
nothing else. But that's not really what happens. They remind people to sign up for it during open enrollment. Even
Yeah.
that, the DOL has found is enough to make it subject to ERISA. They
Mhm.
present it as something they're offering this year as a new benefit. They sort of take credit for like a good benefit offering.
Yeah.
Doing
Yeah.
that brings you out. So I think it's really, really tough to be in. And then the fourth one is that the employer can't profit or be incentivized in any way.
Mhm.
So if those allegations bear out that brokers are sort of reducing commissions that they have to report in a health plan
Mhm.
and putting them
Mhm.
here, that's going to
Mhm.
muck that one up. So I do
Yeah.
think, but even without that, I think it's very difficult to be in this safe harbor and that employers don't realize.
Yeah, no, I think you're right. And I know that there are some firms that offer an online enrollment platform for free, but then they make the commissions on the voluntary benefits, and that's how they sign them up. They use third party enrollers, and a lot of these third party enrollers, their spiel is that they make commissions, as you said, heaped commissions on these big products. And then they say to the broker, hey, we'll do all the enrollment, we'll sign them up, won't cost you a dime, and we're going to make this platform really cheap or free to the employers. Wow. I
Yeah.
hadn't thought of that, but makes sense. It's like
So
rebating, it's like, everything put into one.
it's all in one, yes. And so here employers think, okay, here's something good I can do. It's easy. I can offer this to my
Mhm.
employees. They like it, and I don't have to worry about it. And now it ends up that they really have to worry about it. And
Yeah.
I do think they should worry about it, and they
Mhm.
should immediately sort of review how they're
Right.
handling these, because I do think that if your plan is ERISA exempt, you need to be vetting these policies. Not all
Mhm.
policies are created equal. And
Right.
it is possible to sort of benchmark, because I have also been talking to all these voluntary benefits captives this week
Mhm.
and places like that. And I've met a lot
Mhm.
of interesting people, and that have educated me a lot. According to them, you can target sort of a 50% loss ratio, and you can make sure you can limit broker compensation to
Mhm.
no more than 10%. I
Right.
also found a report that said industry standards really between 2 and 8%. So
Mhm.
there's data out there that you could benchmark. It's just not
Mhm.
happening, and certainly hasn't happened in these lawsuits. And so if I was sort of if I was thinking what would I do now, I don't think if you're a smaller company that you're about to face a massive lawsuit.
Mhm.
However, I do think that if it wins, and if one of these wins, and I do
Right.
think they have sort of staying power to last through the motion to dismiss, because the
Mhm.
allegations pretty good. They're standing. They say,
Yeah.
hey, I paid more than I should have because
Mhm.
you didn't vet these and you breached your fiduciary duty. And so
Sure.
that's a
Sure.
pretty easy to make claim, and it's
Mhm.
100% employee dollars. There's no argument that it's not plan assets. And
Right.
so I
Right.
do think, that there's enough to get past the motion to dismiss. And when that happens in ERISA cases, oftentimes there's settlements that follow, whether or
Mhm.
not you ever get an opinion, or it might be a long time before you get a decision. And before
Sure.
that, a lot will settle, and that sparks more litigation. And so this could be one of those sort of the floodgate area that everyone's been waiting for. It's
Yeah.
not where we thought it would be. Everyone has their finger in
Right.
the PBM hole, and the
Yeah.
voluntary benefits hole sprung a leak. Everyone's like,
Yeah.
oh
Yeah. Wow. So complicated for employers, but
no.
they need to be on top of it. What are the early warnings? Are there different kinds of voluntary benefits that are more vulnerable? And what are the warning signs that they should look for?
Yeah, so I do think that, here for these cases focus on four types of benefit plans,
Mhm.
and these are the four most popular. It's the critical illness, accident, hospital indemnity, and
Mhm.
cancer. And so these are all areas where
Okay.
over the years insurance has covered less of the
Yeah.
total amount, and employees are left with out of pockets. And so that's
Mhm.
what these policies are for, and that's why they're so popular. To be honest, I hope employers don't the takeaway isn't we're gonna stop offering them because this
Mhm.
is, a nightmare, because to the extent employee benefits are a recruitment and retention tool, many
Mhm.
employers won't stop offering them.
Right.
And, they're necessary,
Mhm.
unfortunately, to complement many of today's plans.
Yeah.
But also, those are the 4 plans that are, if no one's vetting them and you're
Mhm.
thinking they're exempt from ERISA and
Right.
I think this is the problem. The first thing you sort of have to do if you're an employer, I guess, is figure out, do we think that our voluntary benefits are ERISA exempt? If we think so, why? Do I even know the 4 safe harbor requirements?
Mhm.
Am I in them? why did I think these were exempt in the first place? Did my broker tell me that? And
Mhm.
another thing I would not be surprised to see happen would be to see if an employer gets dinged on this,
Mhm.
them turning around and suing their broker, because if a broker is advising them that these are exempt without
Right.
giving them the nuances, I could see
Right.
professional negligence charges from that. And so
Yeah.
it's a kind of a mess. Do I think
Wow.
the brokers are going to be found to be fiduciaries in these? No, but
Mhm.
I do think that they're engaged in prohibited transactions because
Yeah.
in ERISA, if you're a party in interest, if you're a service provider to the plan, you can't engage in a prohibited transaction, which would be
Right.
anytime you're getting money like this. And
Mhm.
you might be able to if there's an exemption, but there's not going to be an exemption for this. Especially,
Right.
let me just tell you a few of sort of the allegations that are there.
Mhm.
That the commissions are all embedded in the employee premiums, okay?
Okay. Mhm.
And indirect benefit is tied to the placement of them for the employer in their health plan or other benefits.
Mhm.
And this is invisible, undisclosed compensation. So one thing that came up, a lot of people have been saying, but you're not required to disclose compensation if it's not in the health plan. Right. The broker is not required to. But
Mhm.
if the employer is a fiduciary, you
Mhm.
you are always, and you always have been, obligated to know
Mhm.
what you're paying service providers. Otherwise, how can you know if that's reasonable? So
Right.
employers can't act like, well, it's the broker's fault that they didn't disclose their compensation, or the law doesn't say they have to. Yeah, the
Mhm.
law doesn't say they have to, but the law does say that you have to know it. And so
Sure.
employers, this is the health plan world too. That's why you can't sort of take no for an answer and take a bad
Mhm.
disclosure and just live with it. It's your role as an employer. There's no way you can determine if fees are reasonable if you don't know what the fees are. And
Yeah.
so you have to push.
Yes.
And here this will be a whole new area of push. And I
Mhm.
think a lot of people will be shocked. So say you have Lockton or Mercer or Gallagher or Willis Towers Watson. I
Mhm.
just named all of them because I didn't want to single anyone out. They're
Right.
doing all your benefits, right? Your
Right.
health
Mhm.
plan, maybe
Mhm.
your record keeper, even if you're locked in, that could be in your 401k. They can also
Mhm.
be doing all your voluntary benefits. If you now demand a disclosure that shows all their compensation across
Mhm.
all the benefits that they're placing with you,
Right.
I
Right.
think that's going to be really shocking to some employers.
Yeah. Yeah.
And I think that we just probably have to reimagine again, sort of the broker employer relationship. What is the
Mhm.
motivation here? And another sort of bad statistic here, something like 91% of employees that were polled trust their employer to recommend good benefits for them,
91%.
which I thought was
What?
really high. I was shocked by
Yeah.
that.
I think that's yeah, I wouldn't have expected that.
People trust their employers when it comes to choosing their benefits. And
Mhm.
so that's a
Mhm.
big responsibility and it should be treated. And so that I'm wondering if like non-ERISA plans are sitting out there thinking, I don't have to worry about this. I'm a municipality. I am not ERISA
Yeah.
subject,
Yeah.
but you're a fiduciary and
Mhm.
there is no safe harbor for you actually because you're
Yeah.
not ERISA to begin with. So
Right.
any
Mhm.
benefit you're purchasing with employee funds and taxpayer funds
Mhm. Mhm.
definitely have to know everybody who's obtaining benefits for the purpose of another party and using
Mhm.
their money
Right.
just should act as a fiduciary because
Yeah.
that is a fiduciary
Right.
obligation, you
Right.
know?
Right. Wow. Wow. There's a lot here. This is great. Let's jump and we could go on talking about this longer, but let's jump to what we spoke about earlier, the kind of the sleeper case, the Mayo Clinic case.
I love it.
That surprised a lot of us.
Well, it did not surprise me, and I hate when people
Mhm.
do this, but I'm going to do it because I can't
Mhm.
help it. I've always said that was my favorite of all the fiduciary breach cases that were
Uh-huh.
brought, sort of initially
Mhm.
early on. I thought this was the one with legs. It's not that I don't like PBM cases, but I think they're really complicated. I think
Mhm.
they're trying to change some sort of settled mindset that judges already have. I think it's
Mhm.
a much harder and I'm not sure what the end result is going to be. I can't imagine any court saying that an employer has an obligation to review every single medicine every day and make sure the
Yeah.
price is competitive. So I think there's a lot more difficulty in those cases.
Mhm.
This case
Sure.
is super straightforward. So let me just give you the nitty gritty. I wish I could. Where is the name of this case? How it? I'll send it over so that you can,
Yeah, we'll put it in
it's
the show notes.
Orison v. Mayo Clinic, Orrison, and I'll send it over to you.
Okay.
So when it was originally filed, it was filed sort of anonymously by a parent because, and really the allegations were they tried to get a mental health care provider for their child.
Mhm,
The in-network, nobody showed up. And so there's been a lot of
mhm,
dispute about why. It ends up now what we're
mhm.
going with is that the in-network tool wasn't working properly.
Oh, okay,
So the
okay.
person looked at their plan document and it
Mhm,
said, if there's no in-network providers, you can go out of network and we'll only treat it as in-network. So they did that. And then that is not what happened. The
mhm,
TPA is a self-funded plan, was
mhm.
Medica Mutual, and they said, "No, you should have called us." So the plan document doesn't say that that's what should
Yeah,
happen,
right.
and they charged them the full out-of-network amount. The parent ended up with a balanced bill, and then the parent tried to figure out how they could know. So then it gets even more sort of, it's a whole bunch of ERISA issues all jumbled into one. So the
Mhm,
parent tried to figure out, well, how can I determine the out-of-network rate looking at my plan? And this
right.
is a problem in a lot of SPDs, like almost every one I've ever seen.
Yeah,
It's very vague about how out-of-network benefits are going to be paid. So we
yeah.
might do this, we might do that, we
Mhm,
might look at this benchmark, could look at this public amount, we could look at Medicare, we could look at publicly relied upon documents without naming them. So there's, first of all, there's
right.
like 5 different things. There's no order of how it'll work, and there's no
Mhm,
way you can know what it is in many
right,
cases.
right.
So she's also argued that she can't figure out what benefits will cost on a network. And part of your obligation at SPD is to clearly explain to participants what the coverage is and what's going to cost them.
Right.
And then she just also asked for plan documents, didn't get them. So the case was originally filed and there was a
Mhm.
RICO claim attached. It was a lot.
Wow,
Yeah.
okay.
The
Hmm.
RICO claims have been dismissed, but this complaint has since been amended and
Mhm.
a lot of the counts survived a motion to dismiss. So here's sort
Right.
of what is left is
Mhm,
there's a breach of fiduciary duty claim against,
mhm,
and this is dangerous. So plans have to realize this. The
mhm,
Mayo Clinic had like nothing to do with any of this. They
mhm.
assumed their TPA. This is 100%. All of these things were done by the TPA,
Right.
and Mayo Clinic's on the hook for all of it because they're the fiduciary. So this
Mm,
is a
mhm.
dangerous case. That this is what
So
we're always warning about.
yeah, so this is it's not something Mayo Clinic did. It's something the Mayo Clinic had an employee benefit plan for their own employees, and this is against that plan.
That's right. And
Okay.
they're being sued, in their own name, the plan's being sued, all the fiduciaries, I believe, are being sued. And this is what happens is you get sued for the actions that
Mhm.
even when you delegate because you're
Yeah.
the ultimate named
Yes.
fiduciary.
Yeah.
So here, the claims that are going on, one is a breach of fiduciary duty claim, failing to disclose pricing methodology. And that's
Mhm.
I spent many years learning from Karen Handorf. She used to be my colleague. She was at the Department of Labor for 25 years. She's now at
Mhm.
the Georgetown Center for Health Insurance Reform. Super
Mhm.
smart, ERISA nerdy lady. And she's always been on this hill
Mhm.
beating this drum that you have to tell people how you're paying their benefits. And if you
Right.
don't, you're really risking a lawsuit. And so
Mhm.
I think it's very interesting to finally see this happen. And she repeatedly requested information because she wanted to choose wisely. And the
Mhm.
defendant refused to provide, or the allegations are that there were evasive responses or nothing that made it any easier for her to
Mhm.
understand how out of network benefits would be calculated.
Right.
And
Right.
so what it says is that she was misled by that, and the court said,
Mhm.
well, that can be a breach of fiduciary duty. There doesn't have to be a specific statutory disclosure provision to make
Mhm.
that. That's already the rule in ERISA that this is what an SPD is supposed to do. So there doesn't have to
Mhm.
be a specific thing that covers this. So I think
Right.
that's interesting because I think that a lot of TPAs and employers thought, well, there's no rule that says you have to say this exactly. But
Mhm.
claims regulation and all the regulations governing SPDs already say what's supposed to be in there.
Right.
So then there's a count for deprivation of full and fair review. And she
Mhm.
says that she requested all the reimbursement methodologies when her claim
Mhm.
was not, when she was given the balance bill and they wouldn't
Mhm.
give them to her. And she didn't know how to appeal because they wouldn't give her the relevant documents. And
Right.
the court said that was really a plausible claim because
Mhm.
ERISA grants you procedural claim and appeal rights. And if
Sure.
if you ask for those documents, including reimbursement methodology. So this is
Mhm.
interesting. If you ask for the reimbursement methodology as a participant, you're supposed to
Mhm.
be able to get it. Like, I'm not sure anybody really knows that, because they're going to have to
Right.
start disclosing, like, well, we made a deal with Multiplan and we got this, they got that.
Right. Right. Yeah, and you and I know these things, and there's a ton of people out there that do. Health systems in particular, I've dealt with some health systems where they just have the wrong people making the decisions, and the actual fiduciaries, and the people that make the decisions are also they become fiduciaries, but then the CFO, CEO, et cetera, are listening to the advice of somebody that hasn't necessarily checked all those boxes, and I think more and more I think I spoke to Marilyn last week about this, Marilyn Bartlett, about having an independent consultant review that plan document. Even if you trust your broker, even if you trust your embedded consultant, have a second review. I mean, it's just like having another radiologist look at your x-ray. Second opinions are hugely important and more so with the complexity.
I couldn't agree more. And it's not just your plan document. Like, I feel like I've been looking at administrative service agreements for
Oh, yeah.
years.
Yes.
And there's lots of smart brokers and advisors out there,
Mhm.
but I don't really see anyone, or until recently, saying,
Mhm.
"Hey, you shouldn't agree to that provision," or "This
Yeah,
is, you're gonna forfeit something here if you do
right.
that."
Mhm.
And, like, the contract sort of gets skimmed over. There's this mindset that you can't negotiate these with the insurance company. You just have to accept them. And,
Yeah,
let's just make sure Schedule A is right and, we get you some good performance
right,
guarantees.
right.
Sort of a really basic set of negotiating that isn't really fitting what we need to do today. So
Mhm,
not only do I think you should have an independent consultant look at your plan document, but
mhm.
they should be looking at all your vendor contracts because
Yes.
they're a mess. And
Yeah.
also those vendor contracts have to align with what you're saying in your SPD. You have to make
Mhm.
sure that the vendors are going to do what your SPD says. And here there's
Right.
a real breakdown there. And the third claim that goes forward against both is a No Surprises Act claim for failing to maintain an accurate database. And this is
Mhm.
another area all the time,
Wow.
when I try and negotiate this on behalf of employers,
Mhm,
the provider directory, who's
mhm,
going to be responsible for that. The network is the one that makes this directory available, and they're the ones that are supposed to update it.
mm,
Getting them to agree to indemnify this is like,
mhm.
trying to get them to walk on hot coals.
Yeah.
So the plans really need to get much more aggressive about
Mhm.
negotiating these types of things because they're going to be held responsible in a court.
Yeah.
And so if they didn't do it, they need to find ways to minimize their own liability when they're
Mhm,
not the ones who made this decision and they delegated it. And again, how this ties into what we're just talking about with voluntary benefits is
mhm,
another situation where I know tons of great brokers and I don't think brokers are out there trying to do a bad job. But I
mhm.
do think that the old way doesn't work anymore.
Yep.
And I
Mhm,
think everyone needs to realize that if there's it's a conflict
mhm.
if you have someone on your team that's getting paid on both ends. And it might be okay to have them on your team, meaning if they're
Mhm.
getting a commission from the carrier
Right.
and you're paying them.
Mhm,
But if that's the case, you at a minimum need somebody with fresh eyes, like you're saying, to
mhm.
sort of be on the outside and say,
Yeah.
because then you wouldn't have is part of the reason there's no information about how out of network claims are going to be
Mhm,
paid is
mhm.
because nobody wants to spill the tea about, well, the provider is going to get, on this $100,000 claim, the provider will get 10,000, the carrier will get 30,000,
Yeah.
and
Mhm,
the repricing companies will get another 20. So they make
mhm.
4 times as much as the provider, and
Yeah.
the employer and employee paid way too much for this.
Yeah. Yeah, absolutely, and there's a recurring theme. When I had Chris Deacon on, she has taught us that, yes, you can negotiate that contract. You can bring your own contract to the table. Absolutely. Now, not everybody oversees a huge plan like Chris did in the state of New Jersey, but that doesn't mean that you can't negotiate it, and that doesn't mean that you shouldn't at least read it and understand it and say, "Hey, why is that in there?" 15 years ago, Julie, I was working with a large car dealership in Tennessee, and their ASA, I asked them to look at it, and there was one section, and it said, "You, the employer, have no right to ask your employees or the providers what was charged or what was paid And if you want to know that, you have to go through us to get it. And I looked at it and I said, you signed this agreement and you're saying that they can spend your money, but you can't ask them how, so that was 15 years ago. That was like way back. But
Yeah.
that kind of leads us into sort of the other thing that I wanted to talk about today, and that is your data. Trying to get it. Whose is it? I had Chris Condalucci on a few weeks ago and we spoke about that. Let's jump into that.
Okay. So I have a bit of a contrarian take at the beginning of this, in
Hmm.
that I am aware of lots of court cases where
Hmm.
people have argued about who owns data
Hmm.
in health benefit plans and in other benefit plans.
Right.
And I don't think the results are that great. That to me,
Hmm.
I don't really think that has to be the focus on who is it. What I
Hmm.
think is that if you are an employer offering an employer-sponsored health plan, the claims data, and arguably the participant has some ownership interest in the data, and the carrier, they do put their own pricing mojo on it, so something in there
Right.
becomes theirs. So a lot of people can claim a piece of this. But what's
Hmm.
important is, as the employer, as the covered entity, the plan, so not the employer, you put
Right.
your
Right.
plan hat on. If you're the plan, the covered entity, you have to be able to access that claims data at all times and use
Hmm.
it as needed
Hmm.
to administer your plan, pay
Right.
claims, and make sure
Hmm.
that you're doing things right. That's
Hmm.
just, it's HIPAA, it's ERISA,
Right.
it's the law, it's how things work. You have to have the data if you're paying for the things that data
Right.
results.
Right. Yeah.
And so it's so instead of, it doesn't matter who owns it. What matters is I have unfettered access to it. And that is
Mhm.
really a hill to die on when you're negotiating these contracts. You mentioned something I think is a really great point. Not everyone's a jumbo plan is going to walk in with their own, 32 BJ contract or
Sure.
their,
Yeah.
New Jersey contract. But that doesn't mean you can't send out an RFP where
Yeah.
you take your 10 most important contractual
Mhm.
provisions and
Mhm.
say, these are musts. And
Yeah.
if you can't agree verbatim, you have to respond to this RFP with what you can agree to, because
Yeah.
that's how we're going to vet finalists.
Mhm.
That's where you have the most power ever, is when you're choosing.
Yeah.
And so that's where you have to change these contracts. And what sort of frustrates me that happens regularly is that people get angry, rightfully, when the plan gets overcharged. And everyone knows it.
Mhm.
Their cost containment vendor can see that,
Yeah.
hey, there's a dupe in here and they're saying we have to pay this amount and
Mhm.
we can't even call the hospital to get it back on our own, and we're
Mhm.
going to do it anyways. And then they get a letter threatening to yank the network discount. And they're like, this is not fair. Life is definitely not fair, but
No.
you agreed to all of this in the contracts you signed.
Mhm.
And
Right.
that's the problem, is the plans have a lot of rights
Mhm.
and then they give a lot of them away in these contracts, and they have to
Yeah.
stop doing that.
Yeah. And Julie, I think a really good way, and I was just thinking of this just earlier today. If you are doing your taxes and you told the IRS, yeah, I paid, $12,000 for this, big meal. But yeah, I don't have receipts. You don't have the right to look at the receipts. Like, isn't that
Yeah.
kind of similar? And
Yeah, and
yeah,
I don't think the IRS would like that answer, but
no.
even worse, imagine if you put your money in the bank
Hmm.
and then they used it, and then you
Right.
said, "Well, I I get that you paid my Pepco bill because I wanted you to do that, but the Pepco
Right.
bill was $120." And I said Pepco because that's where I live. That's like the gas company.
Right. Right.
It was $120, but you paid $1,200.
Yeah.
So you have to give me the rest of that money back. And they, oh no, our contract, we have our own contract with them, and that's what we pay. That's the
Yeah.
contract price.
Yeah.
Like,
Yeah.
that's where all the craziness sets in, is
Right.
people are taking your money, and then they're saying it's subject to. And what I also think plans need to realize is that
Hmm.
whether a TPA agrees to this or not, when they're
Hmm.
repricing and adjudicating claims,
Hmm.
9 times out of 10, a court will find them that they're acting as a fiduciary when they're deciding claims or
Right.
appeals. And so there's a real disconnect when you're hiring this fiduciary, for a claims fiduciary, that
Hmm.
is then telling you that their network provider agreements will take precedence over your plan document.
Hmm.
They're just saying we're going to breach our fiduciary duty anytime that happens.
Yeah.
And this is a hard place for plans to be, because
Mhm.
everybody will say that.
Now, if they say something like that, or our own contract will override this, doesn't that give you, the employer, the right to see that other contract?
Certainly, if a payment happens
Hmm.
where you're like, okay, you paid more than bill charges, or this is
Right.
not the amount that we think this would get paid at based on the machine readable files.
Mhm.
Then under the CAA
Mhm.
electronic access rules, they should show you the provisions of the contract that govern that payment.
Right,
They're not
right.
going to give you the whole contract,
No, no.
but
Mhm.
certainly if you ask in the right way and you're savvy enough and cite the part of the law that requires this, you can
Mhm.
get them to show you the provision that's governing this. But then what are you going to do? Okay, they paid it because they decided this is a DRG outlier, and that's
Mhm.
what their contract says they're allowed to do this. Now
Right.
you're stuck, and so
Yeah.
this is the problem with network contracts, is the
Mhm.
problem with networks, right? Is
Yeah.
is that
Yeah. Yeah.
you've signed on to something, you have no idea how it works, and it's not for
Mhm.
your benefit, no matter
Right.
what anybody tells you.
Yeah. Yeah. No.
The biggest beneficiary of all are clearly the insurance carriers that own these networks.
Mhm.
They're the ones that make the biggest profits in all
Exactly.
of this. Next, the hospitals like the contracts.
Mhm.
The only people that don't benefit from them are the people that are required to use them, to get
Mhm.
access to
Mhm.
doctors. And so we really have to work
Sure.
on, changing this.
Yeah. Yeah, absolutely. And it's getting more and more complex every day. And I don't think we can as employers can necessarily rely on their embedded consultants or brokers. And getting a second opinion, getting a new set of eyes might cost you a little bit of money. It's not going to cost a lot in the big picture, but it's going to give you a lot of peace of mind. Sleep insurance. So,
That's right.
wow.
And one of your jobs is to oversee vendor performance.
Mhm.
And if you
Mhm.
don't know how to do that, then you are supposed to hire an expert to do that.
Yep.
And so, being in the healthcare business is expensive. And
Mhm.
I feel for employers, I get this is not what they thought they'd be doing when they opened a business. But
Mhm.
the country has decided that this is how we're going to provide healthcare to the majority of people.
Yeah.
So this is the system we have to work with. And so we need to make it
Right.
better.
Right. Absolutely. And I would love to have you back another time to talk more about that because I could go on forever, but there's so much to talk about. So for employers that are listening and want to get ahead of these issues, how can they see what you're doing, contact you? How can you help them? How can they get in touch with you?
So first of all, they can just reach out to me on LinkedIn. I'm
Mhm.
always trying to monitor, although I'm a little slow on LinkedIn, but I do my best and I respond
Mhm.
eventually. You can
Mhm.
also, I am a member of Judy Group, which just launched yesterday, which is
Okay.
a consulting group full
Mhm.
of it's a small group right now, and there's a bunch of like-minded individuals that
Mhm.
are what you're describing, and what I know
Right.
you do as well, provide sort of non-conflicted, sort of outside eyes and say,
Right.
but I'm also a lawyer and I have my own
Mhm.
law firm, Health Plan Legal Counsel, so that if
Mhm.
disputes arise that require legal assistance, I can
Mhm.
put that hat on and negotiate as a lawyer with other lawyers.
Mhm.
So you can just Google me. I'll get, I
Mhm.
don't know if you have like notes underneath, but I'll
Yeah, yeah,
send you
yeah.
my website.
Yeah, I've got show notes and I'll include that in. Yeah, absolutely. That's great. I love what you're doing. You always bring such clarity. You work through the issues because it's too complex for a lot of employers. And you're right. If they are not an expert, they have to hire one. Just like if they're not an expert in accounting, they need a good CFO.
That's
It's
right.
really no different. Great. Julie, thanks again for coming back on the show. You're always a great guest. So
Thanks
for
for
those of
having
you
me. This is
listen, yeah,
fun.
thank you. For those of you listening, if this episode or others has been good to you, please share it. Like it, subscribe, and if you subscribe, you'll be the first one that gets the show notes and everything else. If you're looking into voluntary benefits, if you want to know more about fiduciary risk or true data transparency, share this episode and get in touch. If you want to contact me, you can email me, Ralph at thebenefitwhisperer.com, or go to fixmyhealthplannow.com or call 832-924-3330. I'm Ralph Weber. This has been The Benefit Whisperer. And Julie, thanks again for joining us today.
Thank you. Great to be here.
Boom.